So it's important we ensure that people that are also called to the bar are men of honor, men of integrity.
How can they resist inducement?
Well, if you are well paid, if by nature you have imbibed this particular attribute and trait that, look, you are a judge whose responsibility is to dispense justice, irrespective of status, irrespective of any interference or any inducement, is by nature. So we must begin to fish out such people and begin to appoint them as justices of the court. It's important. So issue of recruitment process is key. Getting the right caliber of men and women that will man our judiciary, men of honor, men of integrity, men of great learning, but they must have character, above all. So if we don't have them, then that particular country is in a problem, because the judicial system determines a lot of things. Issue of security, issue of welfare, issue of even people coming to a country to invest, knowing fully well that if there are crises in terms of disagreement, matters can be resolved. Not only resolved, but timelessly also, and in accordance with justice. So it has a lot to do with judicial system having it right, yes.
Speaking about resolving issues timelessly, we do know that some Southern African countries who also inherited the British system, they've got a spokesperson.
That's right.
And in those cases, in those countries, cases don't last as long as ours here. Even though, in spite of the Administration of Criminal Justice Act, cases still seem to take long. What's the problem?
Yeah, the ACGA, came into existence in 2015. Remember that there was this issue of practice that when somebody is charged to court in a criminal case, people will come with all manner of objections, and you have to now wait. The substantive matter have to wait until you resolve the interlocutory matter.
The ACGA put the limits.
Beautiful. The ACGA now came in and said, no, you can't do that anymore. If there is any primary objection you have over substantive trial, all of them should be taken together. So after which you can now appeal, which is also helping. Remember that recently some politically expressed individuals were convicted under this new system.
Almost 10, 15 years.
Beautiful, because the new act just came into existence. So over time, the judges are getting to know about this new act, and they are adhering to it. We may begin to see some level of changes in administration of criminal justice, because of that particular law. And the states are being enjoined to ensure that they have a replica of such law in their various states. Lagos State is an example, and some other states are not that.
From what you say, how does that ever happen, wherein judges don't get acquainted with this ACJA such that lawyers even are well acquainted much more than the judges? Isn't that an anomaly?
Well, you see, when a new law comes into existence, there must be some level of seminar, trainings and retrainings and lectures in order for you to know.
But judges are the ones.
No, they are now. They are. The judges are having seminars on that act. Initially, there was this issue of not understanding the provisions of the act, especially on this issue of preliminary objection. Some judges were, sitting down to make pronouncement, giving room. Remember in Saraki's case, he had to appeal up to Supreme Court before the Supreme Court said, never again would they allow preliminary matters under the new act.
Doesn't that speak to the capacity of the judges and the recruitment process of the judges?
When a matter happens newly, it becomes new. Everyone may not be conversant with it. But over time, as I said earlier, judges are beginning to know
themselves with this.
They are now. They are now. I don't think you have seen any preliminary matters now, escaping from the lower court, going to Supreme Court in criminal matters, and they don't allow it anymore.
How do you
because they have gotten to know about that express provision that actually outlaws it, yes.
How do you divorce that relationship between courts, albeit at the state level, from the state governors?
How do you
divorce that relationship?
Well, the executive is different from the judicial arm. Simple, our political, when you read government in school, the judiciary is supposed to be independent of the executive. But they work together, to ensure good governance in a state. But in pronouncement, in trial process, the judges are not supposed to look toward the direction of an executive or the governor.
But that's the reverse is the case. Almost every other state government.
It's not. The judiciary ought to be independent. That is the word. Now, if any judge does compromise, it's a different ballgame. It's a character issue. But independence of the judiciary, most of even our constitution guarantees it. We are not supposed to look towards the direction of a particular executive, state executive, for making their pronouncement.
But do you believe that we've gone past that level where courts at the state level always play the bidding of the governors?
No, we are almost going through that. We are past that level a long time ago. I'm just telling you this. We are past that time a long time ago, because we have had cases against Lagos State government where the state judges have made pronouncement even against the state government. There are several instances.
Would you think?
But it's an ongoing thing. I will not stay here and say that there are no such things. Some of the states, in the federation, but we are advocating it. Serious advocacy is going on. Serious enlightenment that judiciary ought to be independent, both in their pronouncement, both even in the enforcement. We have issue with enforcement. It's a different topic entirely. That judgment of the courts are not obeyed. We have issue. I have 2 cases against the Nigerian police I've obtained. Now it has not been obeyed. I have written to the Attorney General, let this judgment be enforced. Up to now it's not been enforced. So issue of enforcement also goes to the root of independence of the judiciary. And we must insist that court's pronouncement must be obeyed.
That matter of independence of the judiciary from the executive, do you think a separation of the office of the Attorney General and the Minister of Justice, do you think if that happens, it would aid that independence being enforced?
It's a different topic entirely, but I think people are advocating, and there has been some amendment now going on, that we must separate that office. A legal advisor to the government should be different from the Attorney General, who is actually Attorney General for the state. He's the chief law officer. So if you want to have somebody who is an advisor to the governor, separate that office and all that, it goes a long way. Because we have seen a situation where the Attorney General is like subservient to the executive. He doesn't know his responsibility. That is for the state and not for the governor that is in power temporarily. So there has been that ongoing debate, and I know that with the amendment of the Constitution, there is something that will be done with that issue of separation. And very soon we will see it in our country, yes.
And if that happens, you say it will go a long way in enforcing that independence of the judiciary.
Remember that the Attorney General has nothing to do with judiciary. I mean, in terms of function, the judicial arm of government is
completely on its own.
Beautiful, completely.
Now, why I ask, we talked earlier about the spokespersons of the judiciary being the lawyers. Now, if the Attorney General and the Minister of Justice are together, answerable to the executive, he therefore cannot necessarily defend or speak for the judges when he comes before the executive.
Well spoken. You are very correct. You are very correct. Because he will be defending the executive, which is actually what we are seeing presently. And when you separate, I agree that the man now may try as much as possible to protect the independence of the judiciary. Try to insist on it, especially in terms of funding, especially in terms of enforcement. We have issue with enforcement. It's not an issue of funding alone. Because when you make a pronouncement and nobody obeys it, a valid court judgment is not being obeyed, it makes nonsense of the judicial system, and it reduces even confidence of the people.
So the judiciary has issues with 1, equipment, infrastructure, 2, independence, 3, enforcement. How can all of this be sorted out?
We take a look
real quick.
We take a look at other countries like Singapore. I just went to Kenya. I also studied their system, and I see that there is a difference. Even Rwanda. These guys sat down and looked at their judicial system and said, look, these things are bogged down. What do we do to reform our system? They took a holistic look and then begin to go after one after the other. Issue of personnel, the recruitment process. They simplify it and make it more transparent and open. They now look at issue of infrastructure. You enter into a court. You feel confident that justice will be given in this court. There are courts today, you go to some of these eastern states and see a magistrate court where justice is being dispensed. You see that the entire building has collapsed. The benches and all that, there's no air conditioning, not even light. So how can you expect such a court to pronounce judgment and and give you justice and all that?
The magistrate is already angry.
Yeah, he's angry. The man comes in, the condition is not, it's not conducive enough for him to even sit and pronounce, justice. So it's important we begin to take a holistic look. So infrastructure. Issue of enforcement. They took a look at it and said we cannot continue. Even issue of timers, trial process and judgment. They have taken care of it. If you go to Singapore today, their judicial system is working. So we need to borrow from these countries that have moved away from where we are to where they are now and know what they did and follow them up. As I said earlier, even Rwanda, they have all gone far.
But when you say the bench cannot speak for themselves, that the bar has got to wade in at that point, how does the bar do that when they consistently are bogged down with cases in court about their processes, emergence of their leaders?
Yes, but when you're very funny. The part of our objective is to ensure the enthronement of rule of law And as I said earlier, we have to protect the judicial system in this country. So we speak on behalf of the judges when it has to do with their remuneration, when it has to do with their condition. Remember the time their homes were invaded, the NBA came out strongly and spoke against it, that look, the system was wrong. Yeah, you have good intention, you know, that these people, if you are alleged they are corrupt, there are ways and procedures. You must also follow your law. The NBA spoke against it. We didn't see any of the judges actually speaking. They are not supposed to do that. So the NBA is supposed to speak on behalf of the judges. That has been our practice. We inherited it from the British. You can change it tomorrow, but for now, judges are not supposed to be seen, you know, sitting down like this, speaking over their matter.
So has the NBA done that lately about funding of the judiciary, either from the source, appointments of judges, the way they come from state or federal? How have they spoken up about it?
Chamberlain, you've been following all our conferences. Every time, even when we have our NEC meetings, the NBA usually come out with a communique. And almost all the times, and I'm saying this with every sense of responsibility, there has been issue of advocacy for our judiciary to be taken care of in terms of infrastructure, in terms of independence, in terms of enforcement of their judgment and all that. If you look at our communique, both at the conference level, even at NEC meetings and all that, there is always that pronouncement. So the judiciary have always been spoken, you know, on their behalf by the NBA severally. So look at our communique all time. Even the last one